Banca Generali S.p.A. and Simon Credit Opportunities S.A. and Alpha.
Good morning, Mr. Patton.
Good morning.
Good morning, everybody. You can assume that we have read widely and that we're fully au fait with the arguments and the issues in this matter.
I'm grateful for that indication, my lady. May it please your ladyship and your lordships, I appear together with Mr. Rushworth for the appellants in this matter, and my learned friends, Mr. de Mestre, appears together with Mr. Rose for the respondent. And as you know, the sole issue on the appeal is whether the senior note holders have the power, following service of a trigger notice, to remove and replace the fiscal agent without cause. The question is obviously one of contractual construction, and I wasn't proposing to address you on the principles of contractual construction, with which I know you're very familiar and which aren't in dispute. In terms of the structure of my submissions, and taking on board what your ladyship has already said, I was proposing briefly to provide some background to the scheme of the transactions, and in particular to identify the role of some of the key entities within the transaction. Secondly, to take you to the other key contractual provisions, and then to make my submissions on the point of construction. So just beginning with the scheme of the transactions, as you will have seen, the proceedings concern three securitization transactions, which we've been calling TF1, TF2, and TF3, and the first appellant is the issuer under each of those transactions. I should perhaps mention, just by way of an update, that at the end of last week, a sale completed of the vast majority of the interests held by the respondent and its clients in the TF1 securitization. So the very small number of notes still held by some clients of the respondent in TF1, but that's simply by way of update. I don't think that really affects the issues for the appeal. And as you'll have seen, it's common ground. There's no difference between the different documentation for the different securitizations. We've all analysed the issue by reference to the documentation for TF2. In terms of the nature of the securitizations, there's a helpful summary in the judgment, which you will have seen. If I could just ask you to turn up in the core volume at tab 6, page 39. And it's just in paragraphs 4 and 5. In paragraph 4, the judge records correctly that the assets securitized are trade finance receivables, and he gives an indication of what they comprise. And then the overview he gives in paragraph 5, CFE Suisse originates receivables and sells them to the issuer. CFE Suisse is appointed collection agent by the issuer and undertakes the administration, management, and collection of the receivables. The issuer issues the senior and junior notes to the note holders, which the respondent bought and then on-sold. The junior notes were retained by CFE Suisse, and then the issuer agrees to apply all the collections received or recovered from the receivables to pay the obligations due to the note holders. And just in relation to the first 2 points he makes there in 5.1 and 5.2, that CFE Suisse is both the person who originates the receivables and sells them to the issuer, and is also the collection agent. That's a point which the judge makes an important further explanation of in paragraph 33, which is on page 46.
Yes.
And just in the third line, he says, the securitizations in question are securitizations of trade receivables. As is common with securitizations of this type, the assets owned by the vehicle are receivables originated by a trade finance bank, here CFE Suisse. The obligors in respect to the assets are not notified of the fact that the assets are securitized. In consequence, they perceive their obligations as owed only to CFE Suisse. This means that CFE Suisse must in practice manage the property owned by the securitization vehicle, and it would be extremely difficult for any other person to do so without the active cooperation of CFE Suisse. And then he uses the word entrenched to describe that situation. So the point he makes is that when CFE Suisse assigns the receivables to the issuer, it does not give notice to the debtor. And so CFE Suisse remains the entity to whom the debtor will tender payment under the receivables, of the receivables. And that's why, even after the assignment of the receivables from CFE Suisse to the issuer, it makes sense for CFE Suisse, and indeed it's vital for CFE Suisse to continue to undertake the management and administration of the receivables. Now, that point that the judge made in paragraph 33 is reflected when we come to the first of the two agreements with which the court is principally concerned, and that's the master transfer agreement. And that's in the supplemental volume at tab 1, beginning on page 2. And as you can see from the cover page, this is an agreement between the issuer and CFE Suisse. And if I could begin on page 6 with the recitals, this puts a little more flesh on the bones of the judge's summary of the transactions. One sees at recital A that the originators, as defined below, own certain receivables arising from letters of credit and so on, the payment instruments, loans, credit facilities, etc., the financing instruments, or insurance policies in connection with the provision of export services, and some of those payments may be guaranteed. And then in B, pursuant to certain assignment agreements, the seller, that's CFE Suisse, has purchased from Merrill Lynch International, the initial originator, an initial portfolio of receivables arising from a finance instrument granted in favor of the Republic of Angola in connection with the financing of export services provided by a number of entities who are named. So that's the nature of the initial receivables, the portfolio of which is acquired and then assigned to the issuer. And then in C, the seller in the course of its business shall purchase from the initial originator, that's Merrill Lynch, or other export companies, banks and financial intermediaries, further portfolios of receivables. So there's an initial portfolio, but further portfolios may be added. And then in D, pursuant to this master transfer agreement, the seller, CFE Suisse, assigns and transfers, and the purchaser, that's the issuer, agrees to purchase the initial portfolio. And the agreement also regulates the modalities for the transfer of the additional portfolios, and the purchaser appoints CFE Suisse as collection agent for the purpose of collecting the receivables. And then if I could ask you just to turn to page 10, at the foot of the page, clause 2.3.1, the seller and the purchaser shall take such further other steps to effect the transfers and acquisitions contemplated hereby, and then just reinforcing the point that the judge has made, provided that the parties acknowledge and agree that the transfer of the receivables pursuant to this agreement will not be notified to the debtors and the ECAs, ECAs being the export credit agencies. And over the page on page 11, at clause 2.5.1, again that point is repeated. Without prejudice to the legal effects of the transfer of the receivables pursuant to clause 2.4, the parties hereby acknowledge and agree that the transfer will not be notified to the debtors and the ECAs, and that accordingly CFE Suisse will manage the receivables and any collection or other rights deriving thereof on behalf and in the sole interest of the purchaser in its capacity as collection agent pursuant to clause 11. So that's really making the point that the judge made in paragraph 33, because there isn't going to be a notification to the debtors, it's accordingly that CFE Suisse will be managing the receivables.
Are the debtors notified of the assignment to CFE Suisse?
That, I think, is not a point that's addressed in any of the evidence of the documentation, as far as I know.
But if they're not, that slightly removes the force of your point, doesn't it?
It does. So it appears to be implicit in what is said in the contract that CFE Suisse will manage the receivables accordingly. That the debtors know that CFE Suisse is an assignee of the debts. So if I could ask you to turn to page 21, which is clause 11 concerning the appointment of the collection agent. One sees at clause 11.1.1, the issuer hereby appoints CFE Suisse as the collection agent of the securitisation, trusting it with the duties of and conferring to it the powers for carrying out in this capacity all activities, functions and services set out without limitation in clause 11.3 below, and in carrying out the collection services, the collection servicer shall act as agent in the name and on behalf of the purchaser, also in the interests of the note holders. And then one sees a clause over the page at page 22, clause 11.3 headed the collection services, and it provides, subject to the terms of this agreement and the other transaction documents, the collection agent hereby undertakes to carry out, directly or through its delegates, all the activities, and obviously, as you'll understand, we emphasize the word all the activities related to the administration, management, and collection of the receivables transferred to the purchaser under this agreement from time to time. Those are the collection services. And as you will appreciate, that reference to the administration and management of the receivables is obviously a central point on the appeal. And then one has then, simply by way of example, a list of what the collection services comprise, managing the receivables and activities related to the collection. And as you can see, there's a whole host of activities that are under the rubric of administration, management, and collection of the receivables.
Well, that's a very wide list.
It is, precisely. And notably, over the page at page 23, at the letter J, selling the receivables is one of the activities that constitutes the administration and management of the receivables. And then I think finally in this agreement, just over the page at page 24, clause 11.5 deals with the termination of the appointment and the resignation and substitution of the collection agent. And it's upon the occurrence of one of the following events, a collection agent termination event, and they effectively are either misconduct on the part of the collection agent or an inability to perform, for example, because of insolvency. One sees failure to pay, transfer or pay an amount, failure to comply with material obligations, and so on. Fraudulent or criminal conduct by the collection agent. And then over the page at 11.5.2, the appointment automatically terminates if it becomes illegal for the collection agent to carry out their duties. And so it's either misconduct or, if I can call it, incapacity. That those are the bases for terminating the collection agent. There is no option to terminate the collection agent. There is no right to do so without cause. So that, milady, is the collection agent. And then the other entity with whom we are particularly concerned is the fiscal agent. And its role is addressed in the other contract, the fiscal and calculation agreement, which you have in tab 2 of this supplemental bundle, beginning at page 40. And the body of the agreement begins at page 45. And one sees the list of parties. They include, unlike the MTA, the respondent, Banca Generali, which was the senior notes initial subscriber. That's the penultimate entity listed in the list of parties. And then in the first recital, A, one sees a reference to the master transfer agreement dated on or about the issue date and a summary of what that provides for. And we make the obvious point that these two agreements have been entered into as part of a suite of agreements in a single overall transaction, and therefore the court will wish to give them a meaning which is consistent with one another. Now, if I could invite you to page 48, Clause 3.1.1, that's simply the appointment. The issuer hereby appoints CFE Advisory as the fiscal agent for the purposes specified in this agreement. And in 3.2.1, CFE Advisory accepts that appointment. And then on page 52, just at the foot of the page, clause 5 sets out the duties of the fiscal agent, the general duties of the fiscal agent. 5.1.1, it shall act solely as agent of the issuer. 5.1.2, it's required to act upon a resolution of the organisation of the note holders or of a class of note holders, and will comply with those. And then 5.1.3, it shall perform the activities it's required to perform under the rules of the organisation of the note holders, and in particular, issue the certificates and instructions in relation to meetings in a form and manner which comply with the provisions of the rules, and keep a full record of any certificates and instructions issued by it. So in the initial stages of the transaction, it's a fairly administrative role for the fiscal agent, dealing with issuing certificates and instructions in relation to meetings of note holders. That, of course, is expanded when a trigger notice is served, and I'll come to the provisions about trigger notices shortly, but just to identify the impact on the fiscal agent, one sees that at page 65. Clause 14.3 towards the bottom half of the page. And in the second line, following the delivery of a trigger notice, the fiscal agent shall also be entitled until the notes have been redeemed in full or cancelled. And then there are 4 items that are listed A to D. A is, if requested by the note holders, to request the account bank to transfer the monies in the account that it holds into another account opened by the fiscal agent. So essentially to move monies from an account held by the account bank to an account that's been opened by the fiscal agent. B, again on a request of the note holders, to request any party to transfer monies into that account. So again, to do with the transfer of monies. C is the key provision with which you're principally concerned, and that has a number of aspects to it. To require performance by each other issuer creditor of its obligations under transaction documents. Other issuer creditor is defined in the notes themselves at page 92. And it's the third definition on the page. And one sees that it's the collection agent, the seller, the corporate servicer, the account bank, the calculation agent, the paying agent. It includes, you can see at the end of the second line, the senior notes initial subscriber. So that's the respondent in the appeal, the corporate servicer, and any other party which may exceed. So that's the list of the other issuer creditors. Just going back to 14.3c on page 65. So requiring performance by those entities of their obligations under the transaction documents, that's the first aspect. The second is to bring any legal actions, and in the case of a failure by the relevant other issuer creditor to perform, to pursue any remedies available to the issuer in the name and on behalf of the issuer. And then the third aspect, generally to take such action in the name and on behalf of the issuer as the fiscal agent may deem necessary to protect the interests of the issuer, the note holders, and the other issuer creditors in respect of the receivables and the rights and powers of the issuer under the transaction documents. And obviously I'll come back to that provision when I make my submissions. And then finally, clause D, to pay sums due and payable by the issuer to the note holders and the other creditors. So those are the 4 additional rights conferred upon the fiscal agent once a trigger notice has been served. So that is the fiscal agent. And then I said I would show you the provisions about trigger notices. And those are provided for in the terms and conditions of the notes. And as you've seen, the terms and conditions actually start at page 83, so they're scheduled to the FCA itself. And I don't think I need to say anything more about that. And then if you were to go to page 110, please, that deals with the trigger events, condition 11. And it provides that if any of the following events occurs, each of which is a trigger event, and then if we look just to the tail piece, the most senior class of note holders may pass an ordinary resolution determining to serve a trigger notice. And the effect of the trigger notice is that the notes become immediately due and repayable in accordance with the post-enforcement priority of payments. So there's a shift in priorities. And looking at the various trigger events, there are a number of them. But the one that matters for present purposes is A sub 2. The senior notes are not redeemed in full on the final maturity date. And it's common ground that that event occurred in relation to the 3 securitizations, and a valid trigger notice was served in respect of each of the securitizations. Now then, an additional consequence of a trigger notice is over the page, on page 111, condition 12.1, and that's headed proceedings. At any time following the delivery of a trigger notice, the issuer shall comply with all directions of the most senior class of note holders set out in a duly passed ordinary resolution in relation to the management and administration of the receivables pursuant to the fiscal and calculation agreement, including without limitation any direction to sell or otherwise dispose the receivables according to the provisions of the fiscal and calculation agreement. And that is the power which the note holders claim to enable them to remove and replace the fiscal agent. So that's the power in the notes themselves. Obviously, that condition cross-refers to the FCA, and the equivalent provision in the FCA is clause 14.1, which is at page 64 of the supplemental bundle. And that's in very similar terms to condition 12. Following the delivery of a trigger notice, the issuer shall comply with all directions of the organisation of the note holders in relation to the management and administration of the receivables, including without limitation any direction to dispose of the receivables pursuant to clause 14.2. Just picking up on that reference to a direction to dispose under 14.2, one sees that immediately underneath. And in fact, 14.2 says that following a trigger notice, the issuer shall dispose of the receivables. So there is an obligation to do that, but only where the proviso is satisfied. And the proviso, as you can see, is that the proceeds of a disposal would pay off the outstanding principal and interest on the senior notes and any other amounts that stand in the same order of priority. So it's quite a high bar for that obligation to dispose of the receivables to be applicable. It would be a disposal which allows the principal and interest on the senior notes to be paid off. Now, having cleared the ground, I was now proposing to address directly the key question on the appeal, which is whether the senior note holders do have the power to remove the fiscal agent in the events which have happened. Now, in our submission, if you were seeking to answer that question, or to give advice on that question, for example, the natural starting point would be to look through these contracts and to see whether they make any express provision about the removal of the fiscal agent. And if you ask yourself that, the answer is yes, they do make express provision about that, a provision which I haven't yet gone to, and that's in clause 9 of the FCA, which is at page 58 of this bundle. And so one sees clause 9 is headed termination and resignation of the agents. And the agents includes the fiscal agent. And 9.1, revocation of appointment by the issuer. Now, the scheme of clause 9 has two aspects to it: termination without cause and termination with cause. And I'll deal with each of them. But beginning with 9.1.1, the issuer may, at any time, and I pause to interpose that at any time means this is a provision that applies before and after a trigger notice has been served. So the issuer may, at any time, with the prior written consent of the organisation of the note holders, revoke the appointment of the fiscal agent by giving not less than 30 days prior written notice, regardless of whether a termination event has occurred, and without having to give any reason. So a termination event, of course, is different from a trigger event. A termination event, as I'll come to in a moment, essentially has to do with misconduct or incapacity on the part of the fiscal agent. But this clause is providing that regardless of whether there's been any misconduct or incapacity, there is a power of removal. Now, the power of removal, as one sees in the opening words, is vested in the issuer. The issuer may at any time, but that is coupled with the requirement that the note holders also consent to that removal. And so in that sense, 9.1.1 envisages a joint decision. The issuer wants to remove the fiscal agent, and the note holders also want to remove the fiscal agent. It needs both. The issuer can't act unilaterally. It couldn't remove the fiscal agent if the note holders wanted to retain the fiscal agent. And likewise, the note holders cannot act unilaterally. They can't act against the wishes of the issuer. They have to both agree. So that's the scheme for termination without cause. 9.2 then deals with the termination with cause, and it defines, similarly to the provision we saw in the other agreement, a number of termination events, and there are 7 of those. And as I said, they're either misconduct on the part of the agent or incapacity on the part of the agent, for example, because of an insolvency. And then 9.2.2 deals with the implications of the occurrence of one of those termination events. So 9.2.2 provides, if a termination event occurs, the issuer may or shall, if so requested by the organisation of the note holders, or in any case, if the events under numbers 4 and 6 above occur. And 4 is the insolvency event in respect of the agent, and 6 is illegality in respect of the agent, forthwith terminate the appointment of the agent by written notice. And so, drawing the threads together of that, if you have 4 or 6 occurring, so insolvency or illegality, the issuer must terminate the appointment. It's got no choice, it's got no discretion, and it's not a matter for the note holders either. There is simply an obligation on the issuer forthwith to revoke the appointment. If any of the other events occurs, so that's 1 to 3, 5 or 7, the starting point is that the issuer has a discretion, because it says the issuer may terminate. But the note holders can force the issuer's hand and convert the may into a shall, and require the issuer to terminate. And so what it comes to is that for those 5 termination events where termination isn't compulsory, the senior note holders can, if they want, bring about the removal of the fiscal agent. But even if they are happy to leave the fiscal agent in place, the issuer has its own entitlement to terminate the agent's appointment, because it's got its own discretion. And we say that when you look at those two provisions together, what one can see is a clear distinction that the parties have drawn between the rights of the note holders in relation to the removal of an agent, depending on whether there has been termination event, whether there has been misconduct or whether there is incapacity. Where there is no termination event, the note holders can withhold their consent, the consent that's required in 911, and they can block a removal by the issuer. They can ensure that the agent remains in place. But what they can't do in that situation is force a removal. They have no power to force a removal where the issuer is unwilling. Contrariwise, where there has been a termination event, plainly they can force a removal, but the issuer can also remove without their consent. And that is a scheme that makes sense, but on any view it is a scheme which has been carefully crafted and legislated for in detail. And then just looking on at page 60, what happens when there has been a removal? Clause 9.4 deals with the question of the successor agent who is to come in place of the person who's been removed. And clause 9.4.1 provides that following any termination, the issuer shall appoint, with the prior written consent of the organisation of the note holders, a successor agent. And so what that contemplates again is a joint decision on who the successor will be. The appointment is to be made by the issuer, but the issuer needs the consent of the note holders to the successor. And so each side has a veto over who the successor should be. So we say this is a carefully calibrated scheme. It legislates in detail on when a removal is permissible. It legislates in detail for whether it's the issuer who decides or the note holders, or whether they both jointly have to decide. And it also gives them both the right of veto over who is the successor. Now, although there are certain references in the evidence and in the skeleton of my learned friends to concerns about how the transaction has been managed, there is no allegation of misconduct or incapacity on the part of the fiscal agent. That's simply not part of the case. And that's so even though in earlier proceedings between these parties, Mrs. Justice Falk made an order for a substantial body of documentation to be disclosed to the respondent. And so it follows that the clause 922 route is not available to the respondent, and it's not what they rely on. Now, we say that it is significant when one construes this agreement that you simply do not find a right on the part of the note holders to force the removal of the agent in the event of a trigger event. That simply isn't there. And if the intention had been to confer such a right, this is the place where one would expect to find it in the clause that expressly and directly deals with the termination of the agents. It would have been the easiest thing in the world to have a provision which provides that in the case of a trigger event, the note holders can require the issuer to remove the fiscal agent. And if the parties had wanted to agree that, no doubt they would also have addressed how and when that should happen and what the requirements would be in the way that they did in Clause 9. And there's simply nothing of that kind. And we say that's the most powerful indication that it simply wasn't intended that they should have a right to remove the fiscal agent merely because there had been a trigger notice.
What further needed to have provided? Because if the effect of clause 14.1 is simply that the note holders have the power to require the issuers to exercise the clause 9 regime, then the regime is what is set out in clause 9.
That I understand. It becomes circular at a certain point. I'm going to come to clause 14 and to make my submissions as to why that isn't the effect of clause 14. But my first point is that this is a case where the parties have expressly addressed the question of removal. They've done so in detail. They've made quite nuanced distinctions between different scenarios. And you would not expect that clause 14 would, by a sidewind, come in and disrupt that.
I understand that point, and you're going to come on to that. Yeah. I think I was just following up. You were suggesting, I think, that if it was intended that a trigger event would change the dynamic, that there would have been some further provisions as relation to mechanism. I wasn't sure
I see.
what further mechanism would be required, other than that which is already set out in Clause 9.
That's true. It may be that the mechanism, it's simply that, I suppose the point I've really been making is that they've dealt with, do you need the prior written consent, is a direction required, and so on. I mean, it may be as simple as saying, in the case of a trigger event, the issuer shall, if instructed by the senior note holders, remove the fiscal agent. It may not need to be very elaborate.
Because all you say is after a trigger event, things have changed. At that point, the note holders can direct the issuer to exercise its power under Clause 9. And that's a complete code then, isn't it?
You could do it in that way as well, yes. You could.
Well, I think that's what the respondents said.
That's what they say is the effect of Clause 14. And my submission, which I'm developing, is that given the way Clause 9 has dealt with the question of removal, that the language of Clause 14 is an unlikely way to have achieved that. They would have achieved it in a much more direct way if that had really been the intention. Now, the judge, in his judgment, didn't agree with the point we make by reference to Clause 9, and he dealt with this in paragraph 30 of the judgment at tab 6, page 45. It's paragraph 30 of the judgment, and he said that there was nothing which purports to limit the use of condition 12 to exercise the Clause 9 power, and he summarised our argument and said he didn't think it was correct. He said that the argument from absence is always a difficult one in the context of contractual construction, the idea that a particular outcome is not addressed, being positive evidence that the parties not intended it, that, he said, was inherently unpersuasive. And he also said that the documentation is prepared to govern the position when things go right. It does the best it can to provide for the position when things go wrong, but the fact it doesn't specifically contemplate and provide for a particular unintended outcome isn't determinative. And in relation to that, we say two things in relation to his 2 points. We're not simply making an argument from absence, in the sense we're not merely saying there is no express power to remove following a trigger event. What we rely on is the fact that the parties did positively address the question of removal. They specifically applied their mind to that and legislated for it in the nuanced way that they did. And the inference, the correct inference we would suggest, is that they have dealt comprehensively with that in Clause 9.
But you accept, as I understand it, there's nothing in the express wording of Clause 9 to say that it's comprehensive, such as, for example, language that says agents can only be removed in accordance with this clause.
No, I accept that. And as to the judge's second point, that the documentation is prepared to govern the position when things go right and not when they go wrong, we would suggest that's not really true of this agreement. It does actually face up to the things that can go wrong. It faces up to the possibility that the agent is guilty of misconduct or becomes unable to perform its obligations, and it deals directly with that in Clause 9.2. And it does also legislate for the consequences of a trigger notice, and it deals with that in Clause 14. And our point is that what it doesn't do, certainly not expressly, is provide that in the case of a trigger notice, there is an entitlement to remove the fiscal agent. And given the way in which the parties have approached the things that could go wrong, the inference is that they didn't intend that right to be, that power to be available.
What is the key thing here is that, as you said, what Clause 9 does in a number of places is give the issuer a discretion. And that's the key throughout Clause 9, is
yes.
its discretion, except in the cases where it must act on the instructions of the note holder.
Yes.
But what Clause 14 does is it removes all the issuer's discretion thereafter, because once the trigger event has occurred, the issuer must act in relation to management and administration.
Yes. And
I know that's another point.
Exactly.
But subject to that, the issuer must act then on the instructions of the note holders. So, in a sense, there's nothing wrong with your analysis of Clause 9 and its all-encompassing effect. It's simply that the trigger event, which isn't specifically addressed in Clause 9, changes discretion to acting on the instructions of the note holders.
Yes. I mean, it's quite an unlikely, if one thinks about the way that would work in, for example, if you look at clause 9.1, the issuer may at any time, with the prior written consent of the organisation of the note holders, revoke the appointment. I mean, the effect of the argument then is that the issuer is simply directed to remove the fiscal agent, and then this reference to the prior written consent of the organisation of the note holders becomes completely odious, because there's nothing for them to consent to. They've already directed the issuer to act in a particular way, and so it adds
the
nothing.
direction would fulfil both purposes.
I'm sorry, my lord.
The direction would fulfil both purposes.
It would fulfil both purposes, but it's not a natural way of reading clause 9.1 in my submission to suppose that it contemplated that instead of having two decision makers, the issuer making its decision and the note holders making their decision and giving their consent, that actually you collapse that into really the note holders having the whip hand and deciding both points. It's certainly an awkward way of looking at clause 9.1. But I mean, as your lordship puts to me, the point we make in any event is that clause 14.1 simply by its scope does not extend to this sort of decision. And the first point we make about that is that when one looks at clause 14.1 on page 64, it's not, certainly in express terms, it's not dealing with the question of removal or replacement of the agents at all. It doesn't mention the agents. It doesn't mention the fiscal agent, and it certainly doesn't say anything about the removal or replacement of the fiscal agent. And simply reading it on its face, there's nothing to suggest that it was intended to be a bolt-on to the clause 9 regime that does specifically deal with that situation. And as I said previously, it's inherently unlikely when you see how directly clause 9 has addressed the question of removal and replacement, that a clause expressed in this way was intended to disrupt that by a side wind. Second of all, we say that the language used is not in fact apt to cover a direction, forcing the issuer to remove the fiscal agent. And that's because the power is limited to directions in relation to the management and administration of the receivables, and the example given being a direction to dispose of them. Now, clause 14.1 obviously could have said, following a trigger notice, the issuer should comply with all directions of the note holders. That would have been perfectly simple and straightforward language, and that, subject to my point on clause 9, would have achieved what the respondent's argument is on this appeal. Simply, from the point that a trigger notice has been served, there is a sea change. The issuer no longer has a discretion. It simply does what it is told by the note holders. And we say it is significant that it's not simply an open obligation to comply with all directions, a surrender of the issuer's discretion. It's confined to management and administration of the receivables, which is a much more specific ambit. Now, those words are, of course, familiar because they are the same words that we saw in the master transfer agreement at clause 11.3. That's back on page 22 in the first tab.
Sorry, that's page 22.
Page 22.
Thank you.
One sees in the third line all the activities related to the administration, management, and collection of the receivables. So management and administration of the receivables, all of those activities are to be performed by the collection agent. And the specific example that was given in clause 14.1, a direction to dispose, as I showed you earlier, that is, again, one of the very things at the letter J over the page that is within the role of the collection agent. So there is a complete match between the scope of clause 14.1 and the activities which this agreement says are going to be conducted by the collection agent. And as I showed you by reference to the judgment, there's a particularly good reason for those activities to be done by the collection agent because there is no notice of the assignment being given to the debtor. So as far as the debtors are concerned, CFE Suisse is the person who will need to be continuing to manage and administer the receivables. Now, these are obviously very sophisticated commercial parties entering into complex, professionally drafted agreements, and the language is therefore a key insight into their intentions. And the fact that they have used the same language, the administration and management of the receivables that one sees here in clause 14.1, is, we would suggest, the best guide as to what the scope of clause 14.1 power is. And that makes it very difficult to construe clause 14.1 as conferring a power to remove not the calculation agent, the person who is actually performing these activities, but the fiscal agent, who we say is not performing those activities.
Forgive me, that isn't the issue though that whilst these activities of administration and management in relation to receivables clearly apply prior to the trigger, once you have the trigger, the fiscal agent then can take all the money.
The fiscal agent can certainly transfer the money from one account to another.
Its account.
Yes, and that's money that...
So it then has the money.
The money that's actually already been collected.
Yes.
Yes, but
those are receivables.
Well, the receivable is the right to be paid the money.
Well, have a look at the definition of receivable. In the notes.
The existing and future monetary rights. I'm so sorry. It's page 93, the fourth definition from the bottom.
Yeah.
And this is in the conditions of the note. So receivable means any existing and future monetary rights and receivables and ancillary rights of the issuer assigned to the same pursuant to the master transfer agreement. No. Well, my submission, I mean, existing and future monetary rights, those are rights that either rights to the money that already exists now, or rights that may arise in future, for example, if they're contingent or there's a condition precedent or something of that kind. But it's not referring to the cash that's already been collected.
Really?
Because that
isn't cash an existing monetary right? The bank owes you the money in the bank account. It's a monetary right.
Well, if one in my submission, when one looks at the nature of this transaction, the whole point of the transaction is that the cash has not yet come in. There is a right to receive the money, and the idea is that as and when the money is received, that can be used to pay the principal and interest under the notes to the note holders.
It's parked in a bank account in the meantime.
Exactly. And so that
expect.
Yes, exactly.
And while it's in the account, it's a monetary right, isn't it?
Which is existing.
I suppose it is. And your lordship's point about the cash being a monetary right is that what under clause 14.1a.
No, I think my point is that under 14.3.
Sorry, 14.3a.
After the trigger notice, the fiscal agent can take all the money.
Yes, that's true. So the fiscal agent can require any cash that's already been collected. It can require
always collected in future.
Or all the money can be paid into a particular bank account, which is held in the name of the fiscal agent. Yes.
So who is the fiscal agent becomes quite an important thing at that point.
Yes, I accept that the identity of the fiscal agent is an important question, but the question in our submission is the fiscal agent the person who is undertaking the management and collection and administration of the receivables? And under clause 11.3, that person is the collection agent. And that's so both before and after a trigger event. I mean, it's true that the fiscal agent has a power to require the monies to be paid into an account held in its name. It may or may not exercise that power. But subject to that, all of these activities remain ones to be conducted by the collection agent.
But it doesn't help you, does it, if the collection agent is administering and managing? You have to say that the fiscal agent isn't.
Well, I don't have to say that the fiscal agent is doing nothing in terms of the management and administration of the receivables. Suppose it were the case that the fiscal agent decides to exercise one of its rights to, for example, for the transfer of the monies. That would still be only one aspect of the collection services. As one can see in clause 11.3, there's a whole host of different things that are collection services. And insofar as cash has not been collected already, for example, in terms of the ongoing dealings with the debtors, pursuit of the debtors and so on, all of that is still going to be done by the collection agent.
What 14.1 is related to is a whole bundle of matters in relation to which the note holders may give directions. And if any of it comes within the... Well, they may give directions in relation to matters that come within the rubric of management and administration of the receivables.
Yes. Certainly, I absolutely accept that once a trigger notice has been served, the note holder is entitled to give directions to the issuer in relation to the collection and management of receivables. And that's absolutely clear. And what that means is that it's actually inherently less likely that the fiscal agent is going to be getting involved in the management and administration of the receivables, because that is something that the note holders themselves are able to give directions to the issuer about directly. They don't need to do so. They don't need the fiscal agent to do anything in particular. They have a power themselves under 14.1 to give directions straight to the issuer.
Well, the argument is, isn't it, that the note holders direct the issuer as to who should be the fiscal agent who is managing and administering the bank account. The money's in the bank account.
Well, I'm not sure that's not how it. I don't think that's exactly how it's been put so far. But it's certainly. I'm not sure that is. Well, we'll see how my learned friend puts it. But in our submission, what clause 14.1 is dealing with is the power of the note holders to give directions to the issuer, not anything to do with the fiscal agent. It's true that the fiscal agent has a power, if it chooses, under clause 14.3, to require monies to be transferred from one account to an account in its name. But that doesn't affect the fact that under clause 11.3, the vast majority of the role in relation to the receivables remains one that's conducted by the collection agent. And in the case of a trigger event where at least one of the main trigger events is going to be that the note holders have not been paid at the final maturity, there is a shortfall in relation to the principal and interest on the notes. That's likely to be a situation where the receivables haven't already been collected and the money, cash hasn't been collected on the receivables. And it's going to be the collection agent which has the privity with the debtors and is going to be doing what it can to try and gather in those monies. Now, one of the points that we make about this is that the judge held, and I think it's common ground, that clause 14.1 doesn't confer any power to remove the collection agent. And that's because, as I showed you, there is no equivalent of clause 9.1 in relation to the collection agent. There is only a power to remove the collection agent for misconduct or incapacity. And as the judge put it, the collection agent's role is entrenched. And so it would not be possible to give a direction pursuant to clause 14.1 to remove the collection agent. And in our submission, given that the contract, given that the MTA envisages that all the activities in relation to the management and administration of the receivables will be conducted by the collection agent, it would be paradoxical if this clause conferred no power to remove the collection agent, but did confer a power to remove a different agent, the fiscal agent. And the judge didn't accept that, and he made the point that there's good reason for the collection agent to be entrenched, and that's because of its role as the originator and the person to whom the debtor will look to make payment. And that's obviously true, but we respectfully submit it doesn't answer our point that when one looks at the language of 14.1, which is a direct echo of the language of what is the role of the collection agent, the parties cannot have intended that if that language isn't a means of removing the collection agent, that it should be a means of removing the fiscal agent. Now, it was argued below that when you reach the final maturity date of these notes, that the collection agent disappears, that that role falls out of the picture, and that the role of managing and administering the receivables reverts to the issuer. Now, the judge rejected that argument, and it's in the judgment, which is in the core bundle tab 6, page 47. And he rejected that argument at paragraphs 38 to 40. And the key part of the reasoning is in paragraph 39. He said that the wording of the clause that was then relied on didn't seem to be effective to automatically terminate the appointment at the final maturity date. Rather, its function was to lock in the collection agent until that date. He also noted the collection agent had, in fact, continued to perform its function with the active consent of the claimant. Given that on the facts of this particular situation, the active cooperation of the collection agent is more or less essential to the extraction of value from the receivables, that is unsurprising. And then he contemplated the possibility of there being a variation. And so it's common ground, as I understand on the appeal, that point has not been pursued, that the collection agent remains in place even after the final maturity of the notes has been reached. And so we do say, given that the collection agent remains in its role, when one looks at clause 14 and it's talking about directions in relation to the management and administration of the receivables, that is referring to activities which will still be undertaken by the collection agent at that point. The key part of the judge's reasoning then is at paragraph 42, just at the foot of page 47. He said that in respect of any action which an agent is appointed to take, the board isn't excluded from also taking that action.
What does he mean by the board?
He means the board of directors of the issuer.
Right, thank you.
And he also says, he thinks it's also the case that if a different agent of the issuer is also empowered to take such an action, the powers continue to exist in parallel. Put simply, if the effect of the documentation is to grant to the fiscal agent powers to manage and administer the receivables, the fact that the collection agent is also in post and charged with performing that function doesn't mean the fiscal agent would be somehow debarred from exercising those powers, and therefore the question as to whether the fiscal agent had power was unaffected by the question of whether the collection agent was currently in post. And then in paragraph 45, so in paragraph 44, he refers to 14, he essentially quotes the language of 14.3c, and he says, the question is therefore one, as to whether the exercise of a power to appoint a person to perform such a role can be said to be the exercise of a power relating to the management and administration of receivables. He says, I think that must be the case. An agent who has the power to take action in the name of the owner of receivables to protect the interests of that owner seems to me to be necessarily potentially involved in the management and administration of those receivables, and therefore the appointment falls within the scope of the power in 14.1. Now, so the provision that the judge was particularly relying on is 14.3c, at page 65, and in particular the language in the last 3 lines on page 65, generally to take such action in the name and on behalf of the issuer as the fiscal agent may deem necessary to protect the interests of the issuer, the note holders, and the other issuer creditors, etc. And we would suggest that when you look at the different aspects that I identified previously of 14.3c, requiring performance by other parties, bringing legal actions by other parties, pursuing remedies, and generally taking action in the name of the issuer, what it isn't contemplating is that the fiscal agent is taking over the role of managing and administering the receivables that, as we have seen, has been entrusted to the collection agent. It's true, as my Lord Justice Phillips points out, that the cash that's already been received can be held in an account in the name of the fiscal agent. But subject to that point, all of the activities of managing and administering the receivables are still going to be dealt with by the collection agent. And that's for the very good reason that the judge gave in paragraph 33, that because there has been no notice to the debtors, it has to be that way. That's the person that they will see as being the person entitled to receipt of payment.
Well, that may be so, but under 14.3b, the fiscal agent can request parties to transfer documents to transfer monies paid and delivered into the fiscal agent's account.
Yes, that's true.
So basically all monies that come in can come to the fiscal agent.
It can be if that power is exercised. That's true. So far as cash that's been received, I accept that will be held, that can be put into an account that's in the name of the fiscal agent.
And future cash.
If it comes in later.
Any receivables will go into that account.
The receipts, as it were, they can go into that account.
Receivables become cash.
Yes. Once the right to payment under the various financial instruments, the insurance policies, and so on, once that is actually satisfied, it's true it can all go into an account held by the fiscal agent. But otherwise, in terms of all the receivables that haven't been paid, the work of managing and administering those receivables, that is going to continue to be undertaken by the collection agent. And it's true that if the collection agent doesn't do its job properly, the fiscal agent can require it to perform. That's one of the things that it's got the right to do. And
So you're saying the various elements in 14.3
Yes.
are specific and not general, and therefore don't fall within management and administration.
yes,
That's
exactly, my lady. That's exactly our point. Now, the fact that there may be one or a number of activities that the fiscal agent does which happens to fall within the rubric of management and administration of the receivables also doesn't mean that one now comes to regard the fiscal agent as essentially someone concerned with the management and administration of the receivables. That is one of the things that the fiscal agent might be required to do. But as one can see in C, the range of things that the fiscal agent might do. It might have to require performance by some other issuer creditor of its obligations, something which might have nothing to do with the management and administration of the receivables. It might need to be pursuing litigation, that too, not the management and administration of the receivables. And yet, for the respondent's argument to work, we would suggest one has to reach the conclusion that the fiscal agent is essentially the manager and administrator of the receivables. Because
that seems to be ignoring the words "in relation to." What is your submission about the meaning of those words?
Well, I accept that the words "in relation to" are generally broad, but the specific power that they claim is the power to remove the fiscal agent. And suppose one of 10 things that the fiscal agent might be doing has to do with the management and administration of the receivables. The question is, well, what about the fiscal agent overall? Why should there be a power to remove them? The mere fact that 1 in 10 of the things that they're doing comes within that rubric doesn't give you a power of removal. It gives you a power, certainly, to give a direction in relation to that specific aspect. But they're not seeking to give a direction on one aspect of management and administration of the receivables, or indeed on a number of aspects of that. They're seeking to remove the fiscal agent altogether.
I think forgive me, I thought we'd established earlier that within the definition of receivables is the bank account and the assets.
The right to the money in the bank account.
The right
Yes,
to the right to, against the bank. And so why isn't the fiscal agent managing and administering those receivables?
I'm sorry, my lord, would you just give me a moment? Well, Lord, if one goes back to the definition of receivables at page 93,
Yes.
sorry, my lady, any existing and future monetary rights and receivables and ancillary rights of the issuer assigned to the same pursuant to the master transfer agreement. In my submission, what that really is talking about is the rights under the underlying debts. The rights, those are the rights that are being assigned. It's not a right as against the banker to the credit in the bank account. It is dealing with the underlying rights and receivables owed by the debtor. Those are the ones that have been assigned pursuant to the master transfer agreement. And one does see that distinction in my submission in clause 14.3 itself, if one goes back to that at page 65. That when it's talking about the monies held in the account, it talks about in 14.3a to request the account bank to transfer all monies standing to the credit of the account into one or more accounts. And it talks about monies to be paid or delivered to the issuer in B. It doesn't, in my submission, treat those as forming part of the receivables. Once the monies have been collected from the debtors and they are credited to the account, it's true that there is, in a sense, a receivable, because that's the nature of a bank account, that the holder of the account has a right to be paid as against the account bank. But that isn't the receivable with a capital R as defined in the notes, which is talking about what's been assigned pursuant to the master transfer agreement.
So to be clear, I had thought that you said before that existing monetary rights in the definition of receivables would cover monies in an account, which would then come within 14.3. But you've recalibrated that, and you're saying that in fact 14.3 isn't talking about receivables with a capital R at all.
No, yes,
Okay.
yes, and I'm sorry, and I...
No, I just...
It's not a point that's been
clear.
taken before, and so I'm sorry that I didn't deal with that correctly first time round. But that is my submission as to what the definition of receivables means.
So 14.3 is just all about money sloshing about in accounts, and it isn't about receivables.
Yes, it's about the cash that's already been collected in, or that will be collected in once it's been collected, and it's dealing with that. It's not dealing with the receivables that have been securitized, which are the right to be paid under the underlying debts.
A much more philosophical right.
Now, finally, I think there's the question of whether you're assisted in the context of this very sophisticated set of agreements by considerations of commercial common sense. We've made one point on commercial common sense, which is that one of the things under 14.3c that the fiscal agent may have to do is to require performance by an other issuer creditor of its obligations. And that one of the other issuer creditors is, in fact, Banca Generali, the respondent. Now, we say that gives you some assistance in considering the respondent's case, because we would suggest it makes more sense, given that one of the things the fiscal agent might have to do is to pursue the respondent, to conclude that when there is a question of removal and replacement of the fiscal agent, that should happen in accordance with Clause 9. And as I showed you in Clause 9.4, which is on page 60, the appointment of the successor under 9.4.1 is a joint decision of both. And given that the fiscal agent might have to pursue the respondent, it makes sense for that to be a joint decision of both rather than a unilateral decision, which they are simply able to instruct under 14.1. The respondent for its...
It's going to be a joint decision anyway. Under 14.1.
As I understand it, there are cases that the note holders can simply make a direction to remove the fiscal agent and replace the fiscal agent with their proposed replacement.
But the direction is to exercise the power under 9.1.
And perhaps they would say to also exercise the power under 9.4.1. So they do claim a right to choose the successor unilaterally.
But that would only be because they can direct the issuer.
Yes. So it's not a joint decision in any meaningful sense. That they simply instruct us, remove the current fiscal agent, here is our proposed replacement, appoint them.
But this argument, doesn't it work the other way as well? Because given that the other issuing creditors include members of the appellant group, isn't it appropriate that it should be possible to remove the fiscal agent who is also a member of that group?
Well, we would suggest what it suggests is that the issuer. So what we're concerned with under Clause 9.4.1 is the view of the issuer and the view of the note holders. And 9.4.1 envisages that they will both agree on a successor. And that makes...
But that's assuming there is a power to change.
Yes, it is.
In your cases, there isn't a power.
There isn't without our agreement. That's true.
Yes.
Yes.
And yet the fiscal agent has connections with other issuer creditors.
It does have connections with them. Yes.
So isn't this a two-edged sword? Doesn't it cut both ways?
Well, that may be why these sorts of considerations don't assist you beyond, and that really the heart of this lies in the language of the agreement made between these very sophisticated parties. Everyone knew what the transaction structure was when they entered into this. They knew that the various agents, some of them were related parties, and so maybe one simply has to look at the language and say, well, does that really confer a right of removal or not?
Assuming Banca Generali isn't confident that CFE advisory services would sue CFE Suisse SA, for example.
Yes, it would be. Well, yes, well, that may be. But they are not alleging misconduct and they're not alleging incapacity. I mean, plainly, if they had a case for alleging misconduct, they would have a right to remove the fiscal agent for misconduct. And that's really really when one comes back to commercial common sense. The scheme that we discern from the language of the agreement is that there is no power of removal without cause, but there is a power of removal with cause. We absolutely accept that. And that is actually a rational scheme for sophisticated parties to have made, and they should be held to that bargain. And I won't say it too many times, but had they wanted to create a further right of removal, it would have been the easiest thing in the world. And the suggestion that clause 14.1 achieves that is about the last way one would go about drafting such a power, if that really had been the intention. May I just check? Can I just add, just in relation to the point that my Lord Justice Phillips was putting to me, in relation to whether the removal of the point about the fiscal agent having the power to move monies from one bank account to another after trigger notice. I mean, just so the court is clear about this, there's no suggestion that that's actually happened, that the fiscal agent has been asked to move to open a new bank account or for any monies to be transferred to it. So, although that's a that is a power which is conferred by the contract, it's not a power that is in fact been exercised at the point in time when the direction for removal occurred. Unless I can assist you further, those were my submissions.
Thank you very much indeed. Mr. de Mestre.
My Lady, my Lords, it's common ground that for both TF2 and TF3, the final maturity date passed without the senior notes being redeemed, and that following that failure to redeem, that valid trigger notice was served, and that as a consequence, the most senior class of note holders have always had and still have the right to give directions to the issuer in relation to the management and administration of the receivables. And it's also common ground that the conditions of the notes provide in TF2 and 3 that such directions can be given by Banca Generali and by way of written resolution. The question on this appeal is, as the court's already heard, a narrow one, namely whether the judge was right to conclude that this right to give directions includes the ability first on the part of the senior note holders to direct the issuer to exercise the power that it's common ground that it has to remove the fiscal agent without cause. There's no dispute the issuer can remove the fiscal agent without cause. The question is, can it be directed to exercise its discretion to do so? And second, can the senior note holders direct it to nominate the successor? And that the identified successor is Mount Street Mortgage Servicing Limited, an independent entity that deals with the management and administration of receivables such as the present and other matters related to securitisations. And what we say is that the judge was right to accept our arguments that the power given to the senior note holders to give directions in relation to the management and administration of the receivables encompasses the power of the issuer, the discretion of the issuer to remove and replace the fiscal agent. And he was also right, the judge, to conclude that clause 9 of the fiscal and calculation agreement doesn't provide a complete code for the method by which the fiscal agent can be removed in the sense contended for by the appellants. And as a result, the judge was right that the written resolutions that have been provided, which the court has in, I won't show you them, but they're in tabs 6 and 7 of the supplemental bundle, those were valid and should be complied with.
Can I just ask you, a couple of times you said in relation to TF2 and TF3, why are you excluding TF1?
Excluding TF1 because of the point that my friend Mr. Patton made, which is that the notes have been transferred to new owners, and it seems unlikely in the hands of the new owners they will wish at a meeting of note holders to replace the...
That's a subsequent event.
It's a subsequent... Exactly. It's not... I'm just concentrating on TF2 and 3, partly also because the process to get to the replacement of fiscal agent is slightly more complicated in 1. Banca Generali cannot give a written direction to replace. There has to be a meeting of note holders. So the direction it gave in TF1, using powers of attorney, was for the issuer to call a meeting for the purpose of replacing the fiscal agent. So there's this additional step in TF1.
So we've only been looking at the TF2 documentation?
Yes. TF1, 2 and 3 contain the same power to give directions in relation to the management, administration and so forth. It's just the route by which those directions can be given by the note holders is more complicated in TF1.
But has been done.
Well, what's happened in TF1 is a direction has been given by the note holders to convene a meeting of the note holders. So in 2 and 3, the direction has been given in the form of a written resolution of note holders, remove the fiscal agent, replace it. It can't be done that simply in 1. You have to have a meeting of note holders at which the meeting of note holders resolves to pass a resolution to remove.
And has there been that resolution?
No, because the appellants contend that there is no power of the note holders at the meeting that we've asked to be called to remove the fiscal agent. So they say there's no point calling the meeting. So the meeting hasn't been called and taken place. But because the note holders have changed in TF1, if one calls the meeting, the result might be different. It would be a different set of note holders who would have to then decide whether to pass the resolution. The questions of construction are the same, but there's just the reason everyone's
spoken. The issue as to whether the power to do it is
yes.
applies to TF1.
Yes. And I've addressed TF2 and 3 because the practical reality is those are the ones where the issue is likely to have a live
affect this quirk in his judgment. Am I right?
No, because it's irrelevant to the questions of consideration, the questions of construction that he had to consider. It's simply relevant to
It has now become relevant because the note holders are different.
Yes, I mean the question for this court, which this court will answer, is was the notice that was given to call a meeting, is that a valid notice? And if the court agrees with the judge, yes, that notice is valid, and then the meeting will have to be called by the issuer in TF1. But different note holders from those who were note holders a year ago would attend that meeting. Obviously, we know what the outcome would have been a year ago if the meeting had been called, because Banca Generali had powers of attorney to attend the meeting and vote in favour of the resolution. So it's inevitable that it would have passed the resolution. Obviously, it had powers of attorney from the note holders then. It doesn't have powers of attorney from the new note holders.
Yeah.
So the outcome of the meeting would be in the hands of the new note holders. It doesn't affect any of the questions of construction that this court's concerned with. So we say what one has to do to work out the answer to the questions that the judge faced, consider on this appeal, is to look at the three sets of contractual provisions. My learned friend's taken your ladyship through those. I'm just going to look at them again in a slightly different order, but very quickly, to identify the points that we say are the key points to take from them. Mm-hmm. We say what you should do is start with the conditions. And those are in the supplemental bundle. They start at page 83. And one can see, by way of example, the conditions for TF2 provide that there was 60 million euros of Class A notes. Those are the senior notes, and 3.158 million of Class B notes. So what one can see is that approximately 95% of the cash injected into the issuer for the purposes of the transaction comes from the senior note holders. And we say when one's construing the suite of documents, and we accept that one has to construe them as a coherent whole because they form part of one transaction, one still has to bear in mind where all these documents fit into the structure. And we say one starts with the conditions because they sit at the top. They govern the relationship between the note holders and the issuer. And it's the note holders who sit ultimately at the top of the structure. They have provided the money, the vast majority of the money, the senior note holders, to the issuer in return for the senior notes. The issuer, which doesn't have any independent source of funds of its own, then uses those funds from the note holders, predominantly the senior note holders, to buy the receivables, which then have to be managed and administered in order to provide the funds, which the issuer can then use to repay senior note holders. Now, obviously, the issuer could do that itself, the management and administration of its assets, but what it does is it appoints agents to do those things. And the point that the judge found of relevance was that what the agents are doing is simply things that the issuer obviously could do in its own name. It says they sit, we say, below the issuer in the structure. So you have the note holders at the top, and their relationship with the issuer is governed by the conditions. Then you have the issuer, which has its assets, and then you have agents that the issuer appoints. And within the conditions, the two most important are obviously conditions 11 and 12, which start at page 110. The court has seen from condition 11 that various trigger events are identified. As my learned friend pointed out, the operative trigger event here is 11.1A2, the failure to redeem the senior notes on the final maturity date, which for TF2 was the 14th of April 2022. But the nature of condition 11 is that if any of the relevant events occur, the most senior class of note holders have a right to serve a trigger notice. And that trigger notice has various effects. There's some automatic effects one sees at the bottom of the page under the letters A, B, and C. So the issuer can't buy any more receivables. it can't demand any further instalments of unpaid instalments of money due from the note holders, and all the notes become payable. A further consequence is obviously that once a trigger notice is served, one has condition 12.1, which provides that the issuer shall comply with all directions of the most senior class of note holders in relation to the management and administration of the receivables. And we said there are two particular features of this condition which are important. The first is that they provide a power to the senior note holders which wasn't previously available. There was nothing which entitled senior note holders to give directions in this form before the service of a trigger notice, but after a trigger notice, they're entitled to give mandatory directions with which the issuer shall comply. We say, therefore, that this represents a sea change in the operation of the securitisation. There's effectively a switch in control of the securitisation from the issuer to the note holders, and particularly to the senior note holders. Indeed, one can see, if one looks at the priorities of payments, which are 102 and 103, one of the other consequences of the service of a trigger notice is that the senior note holders' rights to principal and interest both rank ahead of the junior note holders. So in the pre-enforcement period, the order is senior interest, senior principal, junior principal. Once one has a trigger notice, senior interest and principal gain priority. That effectively explains that the senior note holders provided the majority of the money. When one of these events occurs, they have the right to give these directions, and that represents a sea change in control, moving it from the hands of the issuer to the senior note holders. We also say that 12.1 is a wide provision. As the court's already noted, it says in relation to the management and administration of the receivables. The words in relation to are themselves wide, but the width of the clause is also evident from the nature of the terms used, which refers to the management and administration of the receivables. And ultimately, that is the heart of the securitisation. The issuer only exists to purchase receivables and to manage and administer them in order to provide funds to pay its obligation, most of which are owed to the senior note holders. So when one looks at directions in relation to the management and administration of the receivables, it's giving the senior note holders a power that goes to the heart of the transaction, because the issuer doesn't really have any other purpose. It doesn't have any independent interest in the receivables. Even prior to a trigger notice, it holds them exclusively for the interest of the note holders and the other creditors. Itself has no private interest in them. So we say condition 12.1 is a wide provision. It's a sea change which provides a significant switch from the issuer to the senior note holders. And we say that's important when you come to look at the powers of the fiscal agent once a trigger notice has been served. Because what we'll see, we say, is a counterpart in the powers of the fiscal agent. It has a relatively or very minor role before the trigger notice. After the trigger notice, it's moved, we say, to the heart of the transaction. And that, in effect, explains, in a nutshell, why the power to give a direction in relation to the management and administration of the receivables encompasses a direction to change the fiscal agent, because of the fiscal agent's central role in the securitisation, including in relation to the management and administration of those receivables. So those are the two key conditions. We then have the two contractual agreements the court has been shown. The first is the fiscal and calculation agreement, which starts at page 40. And one sees it on page 40 and then 45, a list of the parties. This is I think it's right to say this is the only agreement to which all of the relevant agents and functionaries in the structure are parties. So it's an important agreement. And the relevant clause here, which I want to go to first, is clause 14, which we see at page 64. Again, this is a clause that the court's already looked at earlier this morning. Clause 14.1 provides, as my learned friend says, the counterpart to condition 12.1. It provides that the issuer shall comply with all directions of the organisation note holders in relation to the management and administration of the receivables. The one point my learned friend made was, well, that this could easily have said simply all directions of the note holders. We say what one doesn't see from the addition of the words in relation to the management and receivable of the receivables, some intention to narrow the scope of the directions. What it's intended to do is obviously confine the directions to those related to the securitisation. If one had an open-ended clause at all directions, there'd be no limitation. It could encompass matters that fell outside the securitisation. What we say is attempting to be done in condition 12 and 14 is to provide for directions which go to the matters at the heart of the securitisation, which is the management and administration of the receivables. But again, the C change I identified in condition 12 is repeated in clause 14. What we then see also, as I've prefaced, is there's a further C change in the securitisation because of the powers given to the fiscal agent in clause 14.3. Over the page on page 65. Now, my Lord Justice Phillips asked my learned friend in relation to 14.3a and b, whether or not those clauses essentially related to the receivables, the money sitting in bank accounts that's already been paid. It's right that we haven't made an argument as broad as that. We say we don't have to, because what one sees in 14.3, if one looks at A to D, is really provisions that capture everything that's going on in the securitisation and transfer or give the fiscal agent powers in relation to them, which it didn't have before. So if one asks oneself, what does the issuer have to do in a securitisation? Well, it has to retain the money that's already been collected in the bank account. Well, the fiscal agent can take that over under item A. The issuer can say, I want the money that's going to be paid in the future put into a specific place. Under B, the fiscal agent can direct where the money that's going to come in the future goes. And under D, the fiscal agent pays that money out to the people entitled under the priority of payments. So one sees 14A, B, and D deal with money that's already come in, where it's to sit, where money that's going to come in the future should go, should be placed, and D is payment out. When one asks, well, what's left in the securitisation there? Well, the obvious thing is the management and administration of the existing receivables that haven't been paid. And that's what's catered for in C. So what one sees in this clause is essentially is a complete shift of the ability to operate the securitisation to the fiscal agent. It can take control of the money that's already come in. It can direct where the future money has to go. And it controls how the money is paid out. When one looks at C, one says, well, what else is it being asked to do? It's being provided with broad powers in relation to the other remaining aspect of the securitisation, which is dealing with the receivables. And one can see that because there's an express reference in the final part of C to take such action in the name and on behalf of the issuer as it may deem necessary to protect the interests of the issuer, the note holders, and the other issuer creditors in respect of the receivables and the rights and powers of the issuer under the transaction documents. So in a sense, one's got a complete scheme there in 14, if one breaks down A, B, C, and D, to transfer powers to the fiscal agent. As I've said before, the trigger notice and these powers are conferred, the fiscal agent had very limited roles. As far as we can identify, there's a reference, for example, in clause 6.2.3 on page 54, where it steps in if the calculation agent doesn't determine an interest payment amount. As it happens, it's also the calculation agent, so that seems unlikely to ever happen, and it has a power under the rules of the organisation of note holders which can be found at page 114, to convene a meeting. But those are really the only references to things the fiscal agent actually does. By contrast, once a trigger notice is served, it's given these powers under A, B, C, and D, which we say encompass every aspect of the securitisation. Dealing with the money that's come in, dealing with the money that's going to come in, dealing with the receivables, and dealing with paying out the money to the creditors. And that's what you see in order in A, B, C, and D. Effectively, the fiscal agent steps very substantially, if not entirely, into the shoes of the issuer. And so when you put together conditions 12 and clause 14.1, along with the provisions of 14.3, one can see that there's been a transfer of power away from the issuer, first to the note holders, and also to the fiscal agent. And it was for this reason that we said, and the judge agreed, that the powers that the fiscal agent has include powers in relation to the management and administration of the receivables. And therefore, the judge agreed that a direction to change the fiscal agent was a direction in relation to the management and administration of the receivables. We say that was the correct conclusion.
What's argued against you is that the words management and administration are to be found, although not necessarily in that order, in relation to the description in the transfer agreement of the role of the collection agent. And that, it seems to be said that as these documents should, at least to some extent, be read together, that therefore management and administration must be referring to the role of the collection agent.
Well, in a sense, for that argument to have any force, one would expect to see a clear demarcation between the collection agent's powers and the powers given to the fiscal agent here. But when one looks at the powers given to the fiscal agent, one can see that they inevitably, on the clear words of 14.3c, overlap with the collection service. So what one can't say is that the parties have intended to give particular powers to the fiscal agent, which sit in one silo, and powers to the collection agent, which sit in a completely different silo. And so the two have completely different roles. And if one looks at 14.3, for example, in C, it provides that the fiscal agent can take such action in the name of the issuer as it deems necessary to protect the interests of the issuer, the note holders, and the other issuer creditors in respect of the receivables. So it can bring actions in the name of the issuer to protect its interests in respect of the receivables. If one goes then to look at the collection services, which can be found in on page 22, the Master Transfer Agreement. One can see, if one looks at various of these, these will fall inevitably within the power of the fiscal agent to bring actions to protect the interests of the issuer in respect of the receivables. So if one looks, for example, at F, the collection agent can initiate, prosecute and manage judicial proceedings, if necessary, in the name of the purchaser for the recovery of the receivables. The fiscal agent is allowed to bring actions in the name of the purchaser there is the issuer. The purchaser is the issuer there. So there is an inevitable overlap between the powers given to the fiscal agent and those given to the collection agent. Equally, one can look at, in J, it can sell on behalf of the issuer, and O, it can enforce the insurance policies on behalf of the issuer. Those are exactly the sort of things contemplated by 14.3c, where the fiscal agent can, in the name of the issuer, take action to protect its interests in the receivables. So there is an inevitable overlap. And it's not possible. My learned friend's argument would really work might work if there was these two completely separate silos of rights. And the fiscal agent was doing something over here, and the collection agent was doing something over there. But there is a clear overlap. One could also look, for example, at C and D. Those aren't bringing actions, but they're verifying various actions to verify that receivables exist or don't exist. The fiscal agent's powers to act in the name of the issuer to protect its interests could equally include those actions, verifying the nature and existence of the receivables.
It's not clear to me what directions the note holders could give to the issuer in relation to the role of the collection agent.
But what in practice, or as a matter of analysis, in the sense it
Practice or analysis?
well, my learned friend's argument, it can give directions, presumably in respect of any of the collection services identified in the agreement. So it can say, bring that action, don't bring that action, sell the receivable, don't sell the receivable. So one can see that the power given to the note holders can include, the way it works is it directs the issuer, then the issuer has to compel its agent to act in accordance with its directions, because the directions here are always given to the issuer. But the note holders could give directions in respect.
How does the issuer compel the collection agent?
Well, the issuer. So the collection agent obviously is the agent of the issuer. The powers and rights it has as collection agent are the powers and rights that the issuer has, and it's delegated to it. The collection agent is a party to the MTA. It's also a party to the fiscal and calculation agreement. So in a sense, it's a party to the suite of agreements that provide that after a trigger notice, the issuer is bound to comply with directions given by the note holders. So one would say that it, as a matter of the contractual analysis, its power is subject to its obligation to act in accordance with directions of the issuer given to the issuer by the note holders once the trigger notice has been set. I mean, otherwise the scheme just doesn't work because the collection agent says, well, I've got the assets and I'm not going to do anything you tell me. The collection agent is just the agent of the issuer.
Yeah.
It's ultimately its creature. And obviously, once one has a trigger notice, the fiscal agent is able to bring actions in the name of the issuer to compel other issuer creditors and other parties to comply with their obligations. I mean, ultimately, what one does have a situation in which the note holders could give directions in relation to the management of individual receivables and a constant stream of directions. What the note holders say they're also entitled to do is to say, what we would like to do is appoint an independent fiscal agent with experience in these matters, and they can then exercise the rights they have under 14C. And one doesn't live in a world where the management is by the note holders on an individual basis of receivables, giving direction after direction. I mean,
I'm not sure it makes any difference to either party's argument, but there is, of course, a slight difference in the wording, in that, as we see here from 11.3.1 of the Master Transfer Agreement, the wording there is all the activities related to the administration, collection, management and collection of the receivables, whereas in 4.3 it's the management and administration of the receivables, which at least theoretically one might say, well, that leaves out collection of the receivables, although I think your submission would be, on analysis, that's not right.
it would be more. I mean, I think that's
So you would say that's a purely linguistic difference of no substance?
yes, I mean, I think that would require, assuming that the drafter was concentrating on the difference in these various services between management or administration or collection.
Terms, are they?
No, and they're brought together under the term the collection services, but one doesn't see any attempt to define which of the collection services is management, which is administration, and which is collection. And as a matter of language, I mean, management, there may be
Yeah, well,
I mean, one of the ways you
straight
manage-
away from paragraph A is manage the receivables to carry out all activities related to collection.
Yes, exactly. I mean, the management of the receivables principally involves that collection. That's the purpose of them. And so, exactly, I don't think either party has suggested that a management administration would be only some aspect of these services, or there's anything in the language. I mean, what we say really is that when one goes back to the relevant condition and the relevant clause, the drafter has chosen to give the senior note holders the power to give directions in relation to the management and administration. That is a broad, all-encompassing term, which goes to the heart of the transaction, because that's really what's going on here. The money's been provided, the receivables have been bought. They need to be managed and administered in order to provide funds. And so we say, well, that's wide wording. And then when one puts that together with 14.3 and the role of the fiscal agent, one can see the fiscal agent steps into all the aspects of the securitisation, dealing with the money that's come in, dealing with the money that's going to come in, dealing with the receivables, paying out all the money to the creditors. And so that's why we say there is this total shift. And ultimately, that was the argument accepted by the judge in relation to the meaning of the power to give directions in relation to the management and administration of the receivables. It comes from, as I've said, the structure in which the note holders provide the funds, the fact that management and administration is the central feature, it's what the issuer can do, delegates. Before the trigger notice, the note holders have no power to do that. They get this power. Moreover, the fiscal agent assumes these wide powers as well. So that one can see that the structure of the scheme is to switch control from the note holder to the issuer to the note holders and from the issuer to the fiscal agent. And we say it's odd in those circumstances if the note holders could give directions directly to the issuer to cause particular events to happen with the receivables. But what it can't do is change the fiscal agent, who in a sense has stepped into the shoes of the issuer to deal with those receivables. One's actually requiring a more complicated process of individual directions rather than simply appointing an independent fiscal agent who can get on with the job. And we say if there's anything paradoxical about the whole thing, that it would be requiring that approach rather than saying the way these clauses work is to switch the exercise of the discretion to remove the fiscal agent from the issuer to the note holders. I'm going to come to that now. That's really the second point, which is the nature of condition 9 and whether it's a complete
Clause
code. I mean, what's said in relation to 9 is really that whatever the width of the power in condition 12 and clause 14.
9 is a complete code.
It's all irrelevant because actually, one has a complete code in condition 9 for the only circumstances, and they say that either before a termination event, you need two things to happen. The issuer has to independently decide it wants to remove the agent, and the note holders have to agree. After a termination event, a slightly different process. The issuer can do it if it wants, or the note holders can compare it if they want. And it said that those what the parties have done is identify, in a sense, the circumstances in which the note holders have any role in the removal of fiscal agent. But we say that's not what clause 9 is doing. When one looks at clause 9, what it's really telling you is when and how can the issuer remove the fiscal agent. And obviously the issuer has to do that because the issuer has appointed the fiscal agent. The issuer is a party to the contract with the fiscal agent. The note holders aren't a party to that contract. So it's inevitable that one's going to have a regime in which the issuer has to do something because it is the only person who can bring to an end the contractual relationship that it has entered into with the fiscal agent. What we say clause 9 is doing is setting out the circumstances as between the issuer and the fiscal agent when it can do that. And it's telling the fiscal agent that the issuer can remove it at any time in certain circumstances, without cause in certain circumstances, and it can remove it after a termination event. And those are the two. When one looks at the temporal distinction in clause 9, the at any time is obviously referring to at any time before or after a termination event, because the alternative scenario in clause 9 is a termination event. The clause is saying nothing about what happens in the event that a trigger notice is served. And that's what Lord Justice Phillips identified. What our case is that once one has a trigger notice, what the senior note holders have is the power to direct the issuer how it should exercise the discretion it has. We say that clause 9 isn't addressing that or precluding a situation in which elsewhere in the contract is a provision, as between the note holders and the issuer, dictating the circumstances in which the note holders can tell the issuer how it should exercise a particular discretion that it has. And we say, in a sense, it would be a bit odd to see that in 9, because 9 is really telling the fiscal agent how and when it can be removed. It's not dealing with, or purporting to deal, we say, with the totality of the circumstances in which the note holders can tell the issuer to exercise discretion. And obviously, the note holders aren't parties to the fiscal and calculation agreement. So we say it's not a complete code in the sense that the appellants require it to be. It's telling the fiscal agent how and when it can be removed, but it's not dealing with the discretion of the issuer and how and when the issuer exercises that. Is it something that the issuer retains for all time, irrespective of trigger notice or not? And we say, given the enhanced role of the fiscal agent, which plainly encompasses the management and administration of the receivables, the right to give directions includes the right to tell the issuer how to exercise its discretion. And that's not precluded by clause 9. One point that has been made, it said that, well, there would be something odd about being able to remove the fiscal agent, but not the collection agent. We said, but there's nothing, that's got nothing to do with, in a sense, clause 14 or condition 12. That's simply a reflection of the fact that the collection agent is entrenched in a different way from the fiscal agent. And it doesn't tell you that it would be odd to be able to remove the fiscal agent but not the collection agent, because the parties have chosen to ensure that the collection agent can only be removed with cause if certain events happen, and then the note holders have an absolute right to remove the collection agent. So in a sense they have a right, but it's only exercisable in very narrow circumstances. And that in a sense is what they've chosen to do with the collection agent. No doubt, as the judge concluded, for good reasons, which is that on the face of it, it remains the owner of the receivables as regards the third parties from whom they've come. And so its role in the securitisation as the seller and then the collection agent necessitates or requires that it will remain involved because it has a greater role than simply being the collection agent. This is on the face of it the owner of the receivables. And so it's retained in place. But there's nothing odd, we say, in the fiscal and calculation agreement allowing the removal of the fiscal agent by the note holders, but they can't remove the collection agent in the same way. They've just drafted two different provisions. The collection agent is entrenched, and the fiscal agent is not. And after a trigger notice, the direction can be given. And we say, ultimately, the issuer holds the rights it has for the benefit of the note holders. One of those rights is the right to remove the agents, including the fiscal agent, without cause. Where the power is transferred to the note holders, as we've seen on trigger notices served, it makes perfect sense, we say, for note holders to be able to direct who the agent is, who has these very important rights to act in the name of the issuer in respect of the receivables under clause 14. And it makes no sense to say, well, note holders can directly go to the collection agent through the issuer and tell it what to do. But they can't change the fiscal agent who's given all these powers. And we say for those reasons, the judge was right to reach the conclusion that he did on both of the two key points. Unless I can assist you further, that's what I wanted to say.
Thank you very much indeed.
Milady, just two short points in reply. I won't obviously repeat the submissions, and I think the court has heard all the arguments really that need to be made in relation to this issue. But just on the first point, which was the point that my Lord Justice Phillips put to me, that clause 14.3 A and B were dealing with the receivables, and your ladyship was kind enough to say that I had recalibrated in my answer because I gave a very poor answer when I was initially asked about that. I think my learned friend has not adopted my Lord's suggestion, and we respectfully submit that he's right to do so. Since I haven't taken you to this previously, can I just show you why we say my learned friend is right about that? And it's just, if we could look at the conditions themselves at page 84 of the supplemental bundle.
I beg your pardon, could you give me the reference again?
Page 84. This is in the preamble to the terms and conditions of the notes. And does your ladyship have the paragraph begins, it's the second new paragraph above the first whole punch, pursuant to a master transfer agreement. The issue of purchased from the seller an initial portfolio, etc. And it defines that as the initial portfolio. And then during the ramp-up period, the issuer may purchase additional portfolios. The additional portfolios, and together with the initial portfolio, the portfolio and the receivables included therein, the receivables, although there is in fact a further definition of receivables in the terms, from the seller pursuant to one or more supplemental transfer agreements entered into in compliance with the provisions of the master termination agreement. And then the next paragraph says the purchase price of the receivables will be financed by the issuer through the issuance of the notes. And then the principal source of funds available to the issuer for the payment of amounts due on the notes will be collections and recoveries made in respect of the receivables. So one can see there it's treating the collections and recoveries in respect of the receivables as being something separate from the receivables. And if you can, if one reads on, it refers to the securitisation law, and then it says in about the fifth line, the issuer's right, title and interest in and to the receivables, any claim of the issue which has arisen in the context of their securitisation, their collections and the financial assets purchased using those funds will be segregated from other assets, and so on. Now, just in then the definitions themselves, if you could turn to page 87, there's a definition which I don't think you've seen before. It's just below the first hole punch, and it's collections. So collections means all amounts actually and definitively received, including recoveries and the proceeds of any disposal in whole or in part of the receivables by the issuer in relation to the receivables, including any amount paid under the insurance policies. So again, the monies that come in they are defined as collections. It's true that they arise out of the receivables, but they're not regarded as the receivables themselves. And then on page 90, just above the top hole punch, there's another defined term which is issuer available funds. And that's the aggregate of, first of all capital C collections received or recovered during the immediately preceding collection period deposited in the payments account, and then any other amount credited or transferred into the payments account, all amounts of interest. And then again, the proceeds deriving from the disposal, if any, of the receivables pursuant to the fiscal calculation date, and so on. So in my submission, that does support the construction which I put forward by recalibration of the term receivables, that it is dealing with the receivables actually assigned under the master transfer agreement. Once one's getting the money in, that is then treated as either the proceeds of the receivables or collections with a capital C, as that term is used. And so we respectfully agree, I think, with my learned friend, that when one comes to 14.3, A and B, so that's, sorry, on page 65, A and B are not really to do with the receivables. They're to do with the collections, capital C, that are now held in bank accounts, and they may be moved around, but that's not any longer the management or administration of the receivables. And that then leads to my second point, which is responding to my learned friend's point on C, 14.3C, and that is the provision that he relies on and that the judge relied on as meaning that the fiscal agent is concerned with the management and administration of the receivables. And we say that although that clause is broad, it is to be construed having regard to the agreement in clause 11.3 of the Master Transfer Agreement, which is part of this suite of agreements. And as I've already said, in that regard, we emphasize the word all that appears in the third line of clause 11.3, that all those activities are to be conducted by the collection agent. And so construing these harmoniously together, one would construe that in order to minimize any overlap between the role of the fiscal agent and the role of the collection agent. It's true, I accept, that the power in 14.3c could involve the fiscal agent requiring the collection agent to do its job, because that's for example, within the first aspect of C, to require performance by another issuer creditor, including the collection agent. But it is still the collection agent who is going to be conducting the activities, or certainly the overwhelming majority of those activities, even after a trigger notice has been served. And it's particularly unlikely that 14.3c was intended to create an overlap between what the fiscal agent is doing and what the calculation agent is doing, given that under 14.1, the note holders can give directions themselves in relation to the management and administration of the receivables. So that's not a role that needs to be construed as one for the fiscal agent. It's one where the note holders themselves are given a direct power of control. Lady, unless I can assist you further, that's all I wanted to say in reply.
Thank you very much indeed, and thank you to everybody, both those who have spoken and those who have not. You'll be fully aware of how we proceed in this court, that when we are ready, drafts will be circulated and should be circulated only to those whose email addresses have been given to the appropriate clerk, and take care therefore not to include in your circle those who have not been already mentioned, and also you will be completely aware of the way in which consequential issues are dealt with. We hope that you will be able to agree, and if not, very short written submissions, and we'll decide on the papers. So thank you very much indeed.
So one thing, you drew the right lectern.
Oh no, it's annoying.
Someone's cut a sentiment.
Literally, it's bizarre. Done woodwork.
That was sabotage from the last hearing.